Excellent question. I'll refer again to another United States Supreme Court case, and that would be the Lawrence v. Texas case, decided in 2003, in which it overturned the prior case of Bowers versus Hardwick. The United States Supreme Court was asked in 1987 to determine whether or not a criminal statute that criminalized homosexual sodomy was constitutional. And in 1987, the court said, yes, you can have laws that criminalize behavior. That was overturned in 2003 in Lawrence v. Texas. But the problem is the analysis of that. Justice Scalia, again in his dissent, says, based on the findings of the court in that particular case, you could have no moral basis for law any longer. Therefore, you couldn't outlaw prostitution, you couldn't outlaw people who are in bigamous relationships, plural marriage, and so it kind of opens up the door to all sorts of issues if you don't have any moral framework for the basis of law. So if we're going to have a total secular society, then Katie barred the door, and what we recognize as the stability of society through our morally based laws can no longer be if that reasoning takes effect. I don't think the U.S. Supreme Court's at the point where they would agree with that, but that's the direction you go if, such as the Varnum Court, and by the way, I don't agree that there was religious animus was behind the 1998 law that says marriage between a man and a woman, because we have 45 states that have similar laws in place. So therefore, I don't think it was about that at all. It was about what's best for society, and that's why the law was enacted by the legislature.